It seems nearly everyone has an opinion about how lawyers should and should not act. But what exactly are the rules and who enforces them? That's what we're talking about tonight on Lawyers on the Line. I'm Sean Quinn, a partner at Falsani, Balmer, Peterson, Quinn Beyer, and this evening's moderator. Now I'd like to welcome tonight's panelist. Megan Engelhardt, I knew I'd mess it up, Assistant Director with the Minnesota Office of Lawyers' Professional Responsibility, and Eric Beyer, partner with Falsani, Balmer, Peterson, Quinn, and Beyer Law Firm. We're ready to take your questions about legal ethics. Call us locally at 218-788-2844 or call our toll-free line at 1-877-307-8762. And now let's get on with tonight's topic. So Eric, other than maybe your wife and kids tonight watching at home, why else would anyone want to watch tonight's program? Why should anyone care about legal ethics?
Well, as you probably know, my wife and kids probably aren't watching me. They'll probably get an ethics discussion at some point throughout the course of the week. But legal ethics is basically a regulatory system to make sure that the public has confidence that the lawyers are going to be truthful and honest in their dealings with clients, because a client has to have confidence that they can trust the lawyer is going to keep things confidential, that a person is going to be able to get advice from a lawyer that's going to be specific to that one person and not be distracted by some other interest that a lawyer may have. So it's about trust within the system, and basically as officers of the court, lawyers have an obligation to instill in the public confidence in part of our government. So it's a little long-winded, but suffice it to say, the market doesn't necessarily dictate that people are going to be honest and truthful in their dealings with people, and it's fundamental to our government and our system that people can rely upon their lawyers to be there for them, basically.
Okay, so Megan, Eric talks about trust. How do we govern this trust within the legal profession?
Well, the Minnesota Supreme Court has instituted several rules of professional responsibility that cover topics all the way from communications, diligence, conflicts with other attorneys. The rules really do run the gamut of everything from client confidentiality all the way to respect for the profession, respect for other lawyers, judges, and the client. It really does cover a multitude of things. In fact, it's a very large book.
Okay, so if a lawyer is said to have violated an ethical rule by a client or by another lawyer, what's the process by which the lawyer is investigated and dealt with?
Well, anyone can file a complaint with our office. Anyone could file against any attorney licensed in the state of Minnesota. And we have an online website where people can file a complaint online, which is very helpful. We also have complaint forms in Spanish, Hmong, and I can't remember what the other languages are, but if you check out our website, there's several ways that you can file the complaint.
You mentioned the website. What's the website?
lprb.mncourts.gov.
Okay.
Or you can just Google it.
All right, so somebody files a complaint. I suppose that would work too. Somebody files a complaint, and then your office investigates, or somebody else investigates?
It depends on the complaint. Our office receives approximately 1,600 complaints a year. Most, when the complaint comes in that day, an attorney in our office is going to be reviewing it. They look at it and decide if it will be investigated or if it will be dismissed right away. Some of the things that are typically dismissed right away would be complaints sometimes from criminal attorneys about a criminal attorney where the attorney didn't do an adequate job representing them, because the Supreme Court has said that those should be handled through the court system, not through our office. Legal malpractice is sometimes dismissed. Fee disputes are sometimes dismissed right away. A lot of things that we investigate right away are communication issues. and complaints are investigated either in-house if the complainant doesn't speak English, we typically keep that in-house. If it's likely to result in public discipline, we keep that in-house. Otherwise, we send it to the home districts, the bar associations. Each bar association has a district ethics committee, of which Eric is a member, of the 11th District Ethics Committee, and they would investigate it and send a report back to our office.
So Eric, Megan's office sends up an investigation to the local investigating committee here. You're a member of that.
Yep.
The chair assigns the investigation to you. Eric, we want you to investigate. What do you do?
Right. Well, first of all, make sure that I don't have an ethical conflict, like representing somebody that might be involved in it or having a dealing there. But the fact of the matter is we generally know the other attorneys in town, but that isn't an ethical violation as long as we can be, that isn't an ethical conflict as long as we can be impartial about it. So what I do basically is I read the investigation, or excuse me, the complaint, and then try to issue spot, because a lot of times the complaint is just a general complaint, and the complainant doesn't really, know what the rules are and letter of verse and cite and say what violation has occurred. So you've got to kind of glean from the dissatisfaction that the client may have, usually a client may have, as to how that fits within the rules. Then call them. Usually I have a written submission from the attorney who is being accused. I will follow up, have a conversation with that attorney as well, make sure that I've got all the evidence that supports either side, make a recommendation. And the recommendation at that point is then set or discussed at a committee, our ethics office, or excuse me.
Your local committee.
A local committee, we sit together, we talk about it. It's made up of mostly lawyers, but 20% of the board are non-lawyers, which gives a nice, a different perspective. And we talk about maybe issues that may have been missed, or make sure that the the investigation is complete as possible, talk about what rules apply, and then ultimately we make recommendations about whether a violation has occurred, and then we submit the report back to St. Paul.
Okay, so you don't decide if an ethics violation, you can
We make recommendations based upon our investigation of the facts.
Okay, so then you get the report back. Eric's said, I think something is amiss here. What does your office then do, Megan?
At the time we get it back from the District Ethics Committee, an attorney is assigned to look at it. If it's a recommendation that there's no discipline, another attorney in our office looks at it and either signs off and approves that discipline is not warranted, or we disagree and continue the investigation in our office. If there's a recommendation for discipline, we do, it gets assigned to an attorney in our office and we continue the investigation there. All violations of the rules of professional responsibility need to be proven by clear and convincing evidence, which is a pretty high burden. It's just below reasonable doubt. So we definitely have to prove everything clearly, and we contact and communicate with the complainant, let them know kind of what the process is happening, and we give the attorney another opportunity to respond.
Okay, and then ultimately a case comes to a conclusion. What are the potential outcomes for a lawyer other than a finding of they didn't do anything wrong, no discipline?
If there is going to be discipline, there's sort of, I would say, two levels of discipline. There's private discipline, which is a private admonition, which is just a written report of an admonition that goes to the respondent attorney and the complainant.
Sort of you kind of messed up, don't do it again?
Yes. Admonitions are for conduct that is isolated and what we call non-serious.
Okay.
So not stealing. So definitely a
Lying
lower.
and stealing are not going to be there.
Lying and stealing are more severe. We also do have the opportunity to put people on private probation. And that's an agreement between the respondent attorney and our office to go on probation. And we make that agreement, and that's the discipline. And oftentimes that attorney is then supervised by a sort of mentor supervising attorney in their local area and provides reports back to our office. Attorneys that are on supervised private probation might have issues with their trust account, might have issues with chemical use, or mental health issues, and we want to make sure that they're getting the help that they need. They might just have some kind of office management issues and need a little help getting organized.
Okay. And then what are the serious punishments?
Serious punishments would be the second level of discipline, and that includes a public reprimand, public probation.
Okay, so everybody knows about it.
Everybody knows about it. If you go to our website, you can look up any attorney in the state of Minnesota and see if they have any public discipline. Maybe I shouldn't have said that, but you
No,
can. You
look
should
it up.
check. You should check an
I-
attorney out before you
I
hire
suggest
them.
anyone look up any lawyer in my office. I'll be happy with that.
And so there's public reprimand, public probation, a suspension. The suspension can go anywhere from 30 days to indefinitely, and then disbarment.
Okay, and disbarment is for the worst of very, very bad violations.
Yes. I think last year disbarments were less than, it was somewhere between 5 and 10 attorneys. Okay. Last year we did have a record number of public discipline. It ended up over 50 public disciplines last year, which is higher than normal.
Okay. Well, let's get to some specific sort of fact scenarios. We already got a couple of calls. Eric, my soon-to-be ex-spouse has a lawyer who's helping him lie in court.
Of course.
How is that ethical?
Well, of course, interestingly, there are two sides to every story. And usually, when you have a contested situation, what is a lie in one person's eyes is quite maybe different from somebody else's perspective. But the bottom line is, a lawyer has an obligation to make sure that they are exhibiting candor to the tribunal and not enhancing or helping a person actually lie. So if the lawyer actually knows of a lie being perpetrated or about to be perpetrated, a lawyer has an obligation to tell the court if there's perjury, for example. So that person's, it depends on what's going on there.
So if the one spouse thinks the other spouse is lying, that's one thing. If the lawyer knows the spouse is lying, that's a different thing.
Absolutely. As a lawyer, you cannot put forward evidence that you know to not be true. And if you do, you've got to take, and if it happens to come out and you know that somebody has testified completely falsely under oath, the lawyer has an obligation to tell the judge afterwards, and that goes from there. So,
along the same lines, Megan, what about the criminal defense lawyer who, they're meeting with their client privately in the office, hey, we're getting ready for your trial for whatever crime that they're charged with, and the client says, I did it, in one way, shape, or form. They say, I did it. What's that lawyer going to do? Does that lawyer have to, quit the case or tell the judge my client's guilty? I mean, what do they do?
No, they don't have a duty to withdraw. Obviously, we encourage clients to be forthcoming with their attorney. Anything that you tell your attorney is held confidential, and that's part of sort of the keystone of the attorney-client relationship, is that you are somebody who you can tell things to. The attorney may be limited as to, if the client says, well, I did commit murder, but I want to lie about it on the stand. As Eric was saying, the attorney is not going to be able to allow that testimony. But they still can put forth a defense and represent the client. They just can't allow the client to lie about it.
All right, now, and I know this is slightly off topic from ethics, but a criminal defendant still has a right to testify, also a right not to. But what if he says, I want to tell my story anyway. I want to lie. And he's a criminal defendant. Doesn't he get to have his say in court?
He does, but he needs to get a new attorney.
Okay.
You can't allow somebody to get up and lie. And I think that's probably when a lot of criminal attorneys probably say, all right, don't tell me quite everything because, we have to be careful. But they definitely, can get a new attorney, and the attorney could quietly withdraw from representing the client.
right, and that is really important because as an attorney-client relationship its foundation is based upon confidentiality. But there are
That goes to that trust issue that you mentioned.
There are a couple of exceptions. One is that you cannot commit a fraud or or lie in court, and a lawyer would have an obligation to prevent serious harm to somebody if they happen to know a person is going to do something, like say, I'm going to go ahead and,
I'm going to go kill my wife.
or whatever. Yeah, then the lawyer would have an obligation that would go above and beyond that confidentiality obligation.
Okay. All right, so let's go to another question. A little weird, but my lawyer asked me out on a date. I want him to do a good job, but I don't want to say yes to the date. What does this client do?
Gets a new attorney, number one. That probably goes to the, the interesting thing is one of the rules says that a lawyer basically cannot have sexual relations with their client. And you think, well, why is that? Well, there's a whole history of it, and the bottom line is that you end up, there are a couple of things going on. Number one, that it could compromise the objectivity of the lawyer. Maybe if you're in an emotional relationship with somebody, you're not going to be as clear-headed as you could be or should be in order to give them good advice. The other thing is, it's kind of weird, but going back historically, they talk about how lawyers are trained in the art of persuasion, and it's not an even situation. Okay. So the bottom line is lawyers cannot have relations with their clients unless it already existed before the representation started.
Okay. So you can represent your own spouse in court, for example.
Yeah, okay. Right. Okay. Not a good idea, but
it's a separate issue.
It's not an ethical.
It's not an ethical issue.
Right.
Is this a big problem, Megan? Lawyers having sexual relations with their clients in Minnesota?
Sadly, it is. It is actually not a huge problem. We probably get at least a couple of complaints that make that allegation every year.
Annually? Oh, wow.
And we have disciplined attorneys for it in recent history. It can be hard because we do need the client to assist us in the testimony, and that can be difficult for somebody to cooperate with that because it does become public. There was, I think, a few years ago, an attorney who was publicly disciplined because he was having sexual relations with a client and then was billing her for the time. So that was a little more excessive, and he was publicly disciplined and suspended. Yeah. And it was a very sad case. I mean,
he must have been taking advantage of somebody.
He was taking advantage of someone who he shouldn't have been taking advantage of, and that's the sad part.
That really is.
And I think the Supreme Court was very frustrated with somebody doing that and then billing her for the time. Yeah. It was sort of a double whammy of just not appropriate behavior.
No, not at all. Okay. All right, so we have another one, Megan. My lawyer and I, we share mutual friends. I'm afraid my lawyer might share some of the things I'm saying to him with our mutual friends. How am I going to be sure that the lawyer doesn't do that? Well,
absolutely. I mean, this is something that happens, I think, a lot in communities where you know the other attorney. Everybody knows each other. Oftentimes that's something that would be experienced up here in Duluth, is that everybody knows each other. Lawyers have to keep things confidential, and that is something that is very important. I think if a client is very concerned about it, they can certainly reiterate that. This is my concern. Please don't go and talk to Jill about this because it's personal. But the rules of professional responsibility do require that a lawyer not comment about anything. And that could even include just the basic fact of representing someone.
I'm representing Joe Schmo. You can't even say that necessarily.
Right. We have had to, unfortunately, discipline attorneys who have made the mistake of saying, oh, I'm representing so-and-so in a divorce. Well, their significant other did not know that the divorce was forthcoming. And that's not the way that person wanted to tell them. Mm-hmm. So it certainly is, it seems like that would be something very simple. Oh, I just represent someone. But attorneys are trained, to obviously, when I meet somebody who I've met through disciplining, prosecuting them for a discipline violation, and we run into each other at a cocktail party, I don't say, "Oh, it's great to see you again." Knowing me is not exactly a hit.
You're like internal affairs in the police
This is
department.
the last time I want to be in the same room with Megan.
So when I see somebody who I've disciplined, I never acknowledge that I know them
Right.
professionally.
Yeah. So this is the only nice time to see Megan.
Right.
You're in this kind of setting.
Otherwise, yeah.
Nobody likes it. I am not a hit at cocktail
No,
parties.
no. So Eric, another question. My lawyer is dragging her feet. Do I have to stick with her? Can I get another lawyer?
Well, a lawyer has an obligation to be diligent in their work and to communicate clearly with the client about expectations. So that's one issue. So technically, what does it mean by they're dragging their feet? I guess that would be a fact issue. But to answer the question directly, they absolutely do not have to stick with their lawyer. They can terminate representation whenever they want. One of the fundamentals of our system is that people have the ability to hire and fire and seek counsel whenever needed and not be bound by retainer agreements or anything like that. So the fact of the matter is, if a person isn't satisfied with their lawyer, that's fine. It doesn't even have to be an ethical violation. They can terminate representation for whatever reason they want.
I don't like the way he looks, whatever.
Well, yeah, I guess.
You wouldn't have that problem.
It certainly would be something that I would recommend that they talk to the lawyer about.
The dragging the feet part.
The dragging the feet, and see if there's something, maybe a miscommunication has occurred. But absolutely, attorneys can be fired at will. Okay. Even, I think the frustrating part is when clients feel they paid maybe a flat fee for the representation, and they want to make sure that they're getting their value. The attorney does need to return some of the funds if the representation is not completed.
Okay. We got another question, Megan. Someone from here in Duluth. What if your complaint isn't about your lawyer or the other lawyer, but it's about the judge?
An attorney or anybody can file a complaint to the Judicial Board of Standards. Okay. So you could file a
board
complaint.
Similar to yours, except it deals with judges?
Yes, it deals with judges.
Okay. All right. Eric, woman from here in town calls, what if my lawyer is screaming at me? Is that an ethical violation?
Well, no. I can say that they have a duty. You've got a general duty to be respectful, and that is just going to create problems. I think the quickest solution is to make sure that you address that with your lawyer, and then seek other counsel if that isn't rectified. But you have to clearly communicate. Theoretically, could there be something there? I guess so. But being boorish or isn't necessarily an ethical violation, unless you've seen screaming discipline cases, Megan?
It does depend if they've screamed something that would be obscene. Yeah. Then that would certainly be something, but that's more the obscenity than the screaming, I guess. Ideally, people are not screaming at their clients. Right. I'm certain that it probably has happened.
Okay. So it may not necessarily be an ethical violation, but as just discussed, go get another lawyer if you don't like it.
One of the things that we talk about in our ethics meetings are whether it's an ethical violation versus best practices. Sometimes it's a bad idea. It's going to lead to additional problems. If you have a situation where you're butting heads with your client, eventually things are not going to go well, and it's going to lead to bad things. So it's a poor way to practice, that's for sure.
All right, another lady in town calls. What if your lawyer does tell the other lawyer something that they weren't supposed to do or weren't supposed to say?
Well, there's two parts to that. First of all, if your lawyer did reveal confidential information, I would recommend getting a new lawyer. And you might need to take measures with the court to make sure that some of that maybe would be sealed or protected. And you should definitely file a complaint with our office.
Okay. Now, we talked about changing lawyers. Somebody calls and says, well, I did change lawyers, but my old lawyer won't give me back my file because he says I still owe him some money for, the retainer. But I don't have any money. Do I have to pay to get my file?
No.
Eric?
Oh,
okay.
sorry.
Go ahead.
Sorry.
Yeah.
No.
Yeah. No.
No.
Yeah.
An attorney cannot hold a client's file. And notice I said client's file. The file is the client's. Obviously, the lawyer is entitled to be paid, but they need to promptly and quickly move it to the next attorney. And if they don't get that file in a timely fashion, they should file a complaint.
Basically, when I was looking at that, reviewing the rules as they're coming here today, and basically what it comes down to is the file can never, the transfer of the file can never harm the client. And basically, if there's a fee dispute, well, there is a different process, or if there's a collections issue or something like that, well, they get in line like any other creditor, but the file has to go, you deal with the money afterwards. Okay. But one other thing, getting back to one of the other questions that you had said, a lawyer does have a duty of confidentiality, but some things are implicitly waived for purposes of representing the person. So there may be some things that they don't want to talk about, a person might not want to talk about, but it's fundamental to the case and it has to be talked about, so you've got to figure out what kind of confidences are.
Okay, so we're almost out of time here, so one last question. What if the lawyer committed malpractice? Is that unethical in and of itself?
It may be unethical. It also may be legal malpractice. So they should file a complaint and they should seek an attorney specializing in legal malpractice.
Legal malpractice is basically a separate cause of action where the client can sue the lawyer for damages. Ethics is more of a disciplinary process.
They certainly do overlap, but they don't necessarily.
The mere fact of malpractice isn't necessarily unethical.
Yes,
okay.
Exactly.
And vice versa.
Yep.
Okay. All right, well, that's all the time we have. I want to thank our panelists for sharing their knowledge tonight. Remember, you can watch the show again online at www.wdse.org or on the Falsani, Balmer, Peterson, Quinn, and Beyer website. Please join us again next week when we will answer your questions about estate planning and probate. I'm Sean Quinn. Good night.